SJC-13070, Pamela, Laramie, and others, v. Philip Morris USA, Inc., and others.
Okay, Attorney Trotch, whenever you're ready.
Thank you, Your Honors. May it please the Court, I'm arguing on behalf of Appellant Philip Morris USA. Now, while I intend to spend the bulk of my time on the arguments regarding punitive damages, we do believe that the numerous evidentiary, instruction, and argument errors that occurred were in fact errors and were sufficiently prejudicial to warrant a new trial. And if time permits, I would specifically like to address the argument related to the erroneous admission of evidence from the FTC reports pursuant to the ancient document rule. But I'd like to begin with our argument that Mrs. Laramie's claim for punitive damages is barred by res judicata. The test for determining whether res judicata applies is clear. It's not in dispute. It requires three elements. One, privity. Two, identity of claims. And three, a prior final judgment on the merits. Most of the disagreement on the law here and in the briefing is on the first prong, whether Mrs. Laramie and the Attorney General were in privity with respect to Mrs. Laramie's claim for punitive damages. Now, under this court's case law, answering that question requires an assessment of two primary things. One, the nature of the interest at issue and whether that interest was adequately represented by a party to the prior litigation.
I don't think this first question is going to surprise you, though. The Attorney General is interested in dealing with all the Medicaid expense related to tobacco. And the litigants in this case are concerned that Frederick Laramie died as a result of tobacco use, and that he didn't really understand what he was getting himself into. And that the punitive damages in that case, although reflecting a public concern, are different from the 93A damages and their purpose in the 1998 litigation and ultimately MSA and consent decree. So that the two litigations are just for a different purpose and a different result. So much so that the AG's amicus brief says, we didn't even obtain punitive damages.
Sure. That's not, you're right that that's not a surprise, Your Honor, and I think I have a few different responses to that. The first is, as to the question of whether what the Massachusetts Attorney General was seeking in terms of punitive damages under 93A Section 4 in the initial claim is the same as what Mrs. Laramie is seeking in this case. You don't look at whether other purposes of the suit are different. The question is with respect to the interest at issue with the punitive damages claim, right? We concede that Mrs. Laramie's individual interest in seeking full and fair compensation for the harm to her, purely private injury, was not represented in the prior litigation, and that the Attorney General was not in privity with her with respect to that. That's a separate question with respect to her punitive damages claim. And under the law, her punitive damages claim is fundamentally a public claim. It is a claim that seeks to punish and deter Philip Morris from engaging in conduct that violates the law. That conduct at issue in this case is selling cigarettes that are unreasonably dangerous and in breach of the warranty, that Mr. Laramie smoked in the early 1970s, caused him to become addicted. So the question is, when the AG brought a claim under 93A Section 4, that's separate and apart, by the way, from the Mass AG's ability to seek Medicaid. They certainly brought a claim to seek reimbursement for Medicaid. And if that was the only claim they brought, we wouldn't be here, Your Honor. They also brought a claim under 93A Section 4. And under 93A Section 4, they are seeking penalties and enhanced damages for the violation of law that harmed Massachusetts residents. It's precisely, and they're operating pursuant to the public's interest in punishing and deterring unlawful conduct within the Commonwealth.
There's no doubt that the punitive damages or the treble damages are getting at a public harm. That's not, of course, the be-all and end-all, though, because what the Attorney General is seeking to achieve is not really representing what Mr. Laramie's family is seeking to achieve, such that there's that privity that's required beyond just that, taking your point, that there's a public aspect to the punitive damages and the treble damages.
You're right that what Ms. Laramie is seeking in this suit as a whole is in part full and fair compensation for the wrongful death of her husband, and is in part punitive damages. And what we are saying is the Mass AG suit was not completely coextensive with her claim. It was not seeking everything that she is seeking, nor could it. The Mass AG cannot bring a claim that it seeks to recover damages for individual harm. What we are saying is when the legislature says in a wrongful death case the jury is permitted to give punitive damages in the case, what is the legislature doing? The legislature is saying that the jury in that case can exercise the state's right to punish and deter unlawful conduct that was done in a particular way in the Commonwealth. That's its purpose. And our argument is and this is clear from Judge Littman's opinion in the Fabiano case that we rely on in our brief. What he said is that fundamental purpose of punitive damages, the public purpose to punish and deter unlawful conduct, is exactly the purpose that underlies an AG claim under a state consumer protection statute. In fact, the only authority that the AG has is the state giving it the authority to punish and deter unlawful
Let me
conduct.
go where you were going for a moment, if I could, please, to get some help here from out of state. Of course, you know that the AG will distinguish Georgia and New York because of on whose behalf litigation was brought. But what do you say about the case from, I think it's, is it from California? The Engel case?
Well, there's
Engel
two, Your
versus
Honor.
Liggett Group from Florida, I'm sorry.
Right.
What about the reasoning in Engel versus Liggett Group, the 2006 case, as it relates to the point that you were making in Fabiano?
Right. So Engel versus Liggett is distinguishable on numerous grounds, Your Honor, that we discuss in our brief. One is that that was not a case that was settled pursuant to the MSA. There was a separate settlement with separate release language and a separate understanding of what was being resolved than the MSA, which was the New York case and the Georgia case. But secondarily, Your Honor, what that case made clear was that the underlying claim that was resolved in their separate settlement only sought punitive damages with respect to a particular type of conduct. In that case, it was false advertising. It didn't seek a claim for all of the unlawful conduct that was underlying the individual claims in the Engel class action that was being litigated at the time. And so they said, while there may have been privity with respect to some punitive damages, there was not privity with respect to the actual punishment sought for the unlawful conduct that was at issue in that case. That's not the case here, Your Honor. If you look at the Mass AG's complaint, they clearly were seeking to punish Philip Morris for the exact same conduct that underlies Mrs. Laramie's claim, I
don't understand that at all. I mean, the AG expressly protects the right of individuals to file suit. The AG is focused on the fact that this is increasing the health care costs for the entire state, but it's not. To me, it looks like Williams versus R.J. Reynolds, the Oregon Supreme Court case, is exactly on point. The Supreme Court has held that punitive damage may not be awarded to punish a defendant for harms to persons who were not parties to the litigation. So here Laramie is seeking her own, or his own punitive damages for the injury caused to him, which was expressly excluded by the AG. So why can't he get punitive damages for himself?
Two things. What Williams says is that one individual seeking punitive damages cannot seek punitive damages for harm to another individual.
But that's exactly this situation. This person's trying to get punitive damages for herself, isn't it?
And our argument is not that when one individual seeks punitive damages, they can't seek punitive damages for another individual. Our argument is when the state comes in and exercises the right to punish on behalf of all the citizens.
But it doesn't. Here it says that we're reserving the rights of individuals to seek their own recovery.
Their own recovery for their private individual harm for their distinct
But-
individual claims.
But can't they also have a punitive damages claim for their private, it's, your sort of public theory of punitive damages is not the current law, I don't think.
I think it is, Your Honor. If you look, for instance, at Williams and the Supreme Court case law on what is punitive damages. What is somebody seeking when they seek punitive damages? Is it just an individual claim or is it a public claim? And if you look at the law on punitive damages, the Supreme Court makes clear. It says in USA v. Williams, this court has long made clear that punitive damages may properly be imposed to further a state's legitimate interest in punishing unlawful conduct and deterring its repetition.
I'm going to lose you, and I actually am confused by the first argument. Could I ask you a question on the breach of warranty design issue? So, and how it relates to the sort of the confidential internal documents. I'm just trying to understand that. So in Evans, this court says you can bring this kind of design warranty claim, right? That you could have designed a safer cigarette. Isn't all that internal research, and I haven't read it yet, but doesn't that internal research relate to that design defect claim in the sense that your client knew much more about the dangers of the cigarettes? Is there stuff in there that talks about how we can cut down on the nicotine, but that'll have, is there stuff in there like that?
So there was evidence about internal research regarding the ability to design a cigarette to deliver less nicotine. Not challenged in this case, Your Honor.
Right,
What is being challenged is separate and apart from that, which is internal research and knowledge, not about the design of a cigarette, but about how dangerous cigarettes are, whether they in fact cause cancer.
Right.
Those two things are completely separate.
So when we go through this record, which I haven't done yet, we're going to be able to create that clear division between all this analysis that your client is doing and other cigarette companies are doing. We're going to be able to distinguish it all and say none of it has to do with whether you can design a safer cigarette or that we know how dangerous this nicotine, the way it's coming in is. None of that's going to overlap. We're going to have that clear dividing line.
Yes, Your Honor, we do believe there's a clear dividing line. And again, particularly in this case, because the dangerousness aspect of cigarettes is really not from the nicotine, right? It is from the carcinogens that occur. So there's separate research analyzing carcinogens, the effect of carcinogens in smoking, separate and apart from the issue of nicotine delivery, and so we do think it's perfectly clear that you can separate the analysis and research and documents regarding the dangerousness of cigarettes on the one hand, and the internal research regarding can we design a cigarette that delivers less nicotine.
Mr. Trash, I know we're taking you back and forth, and I do have a question on the evidence issue, but I don't think you were finished with res judicata, and I'm sort of not finished either.
Sure.
On the identities of the cause of action, there's sort of a simple argument being made, that I'm sure you'll address, which is punitive damages are not a cause of action. But even putting aside that rather straightforward argument, the AG litigation is dealing, the cause of action is fulfilling a federal mandate relative to Medicaid. That's just not the same cause of action as pursuing your rights under a wrongful death statute as a plaintiff's decedent or executor. On the second element of privity,
Yes, Your Honor.
of res judicata, excuse me.
And the answer to that is, there's no question that some portion of the Mass AG's claim was seeking exactly what you're saying, which is the Massachusetts reimbursement for damages from Medicaid. That is not what they were seeking when they brought the claim under 93A Section 4. And of course they couldn't, Your Honor, because Section 4 requires you to bring a claim because people in the Commonwealth have been harmed. That is the mechanism by which they can bring a claim. So they didn't have to bring a 93A.
Can I stop you, counsel? What is that claim called? The 93A Section 4 claim, what is that called? Is it called wrongful death?
No, it's an exercise of the state's authority pursuant to the...
For unfair competition?
Unfair competition.
So it's an unfair competition claim. Why is that the same as the wrongful death claim?
So again, Your Honor, it is not the same as an underlying private cause of action for wrongful death. But what it is, and again, it doesn't have to be the same claim or cause of action. That's perfectly clear. For identity of claims, doesn't have to be the same cause of action. That's the law in Massachusetts. And I would cite, Your Honor, to...
Right, that's the transaction approach. Is that what you're talking about?
Well, that's right.
Yeah, and so for the AG's claim, the transaction was, wasn't it related to the Medicare? No, you're saying that 93A Section 4 was a totally different claim.
It was a totally
for
different
unfair competition based on fraud?
It was based in part on fraud. It was also based in part on selling defectively designed cigarettes that breached the warranty. And that is precisely the punitive damages portion of the claim. And that's really where you get to identity of claims. If you look at the law on what it means to have a same claim, we cite to Boyd v. Jamaica Claims Cooperative. It says, the statement of a different form of liability is not a different cause of action, provided it grows out of the same transaction, act, or agreement, and seeks redress for the same wrong. And our argument is, when the Mass AG brings a claim under 93A Section 4, saying, we are bringing a claim against you for, among other things, defectively designing cigarettes, having too much nicotine to cause addiction. We are bringing it under our authority under 93A Section 4, which allows us to bring civil penalties, enhanced damages, fines, and injunctive relief for your conduct that harmed all citizens of the Commonwealth, including Mr. Laramie. We are bringing that claim and we're seeking to punish you for that. That is an exercise of the state's authority to punish under 93A. Now, once that claim has been decided and fully and fairly adjudicated, it can't be the case that each of those individuals on whose behalf the state was asserting that 93A claim for the very same conduct can then, in their individual cases, not only seek full and fair compensation for their individual injuries, but then seek to assert the state's right to punish for the very same conduct that the Mass AG already prosecuted in the underlying claim. That's the essence.
And I know that we've run out of time, but my next question was, given that Mr. Laramie died long after the settlement, I guess I'm trying to figure out why his claim is covered in this punishment, even though his was yet to come. Are you saying that the AG's case was forward-looking and extinguished it for all time?
Two responses to that. There's no question that the underlying claim for wrongful death had not accrued at the time that the Mass AG case was concluded with the consent judgment. The separate question, however, is whether the state's claim to punish Philip Morris for the conduct at issue had accrued. And that clearly had. The conduct at issue that is being punished is the selling of cigarettes that were defectively designed to Mr. Laramie in the early 1970s that caused him to become addicted. That was the claim at issue in this case. And that conduct, the selling...
So if I'm a 16-year-old child and I get addicted today, that claim is not covered in connection with this suit, with the 1998 settlement. It's only because of the consequence that Mr. Laramie happened to fall within the window.
I think that's the primary argument is that, Your Honor. Now, there's an argument, if you read the language of the release, that it did that the state for.
Well, that's a
states-
contract claim. I'm talking about res
That's
judicata.
right.
For
I
res
think for res
judicata, if
judicata-
I'm a 16-year-old today, I get addicted, I have a claim against Philip Morris.
I agree with that. On
Okay.
pure res judicata grounds, Your Honor, it would not apply. The point is that it was aiming at conduct that occurred before the Mass AG case and that is described in detail in the Mass AG's complaint. And I think that's important because one of the claims was that what they were really doing is seeking Medicaid claims, and to the extent that they were seeking 93A, it was just for fraud. If you look at the actual complaint, there's 58 pages of factual allegations in that complaint. Fully half of them deal with the issue of defectively designed cigarettes, Your Honor. And I'll just very briefly, I recognize that I'm out of time, but their complaint is at Appendix Volume 3, page 297. And the factual allegations that deal with the exact conduct that was underlying the punitive damages claim in this case begin at page 304 of Volume 3 under the heading, The Role of Nicotine in Smoking. It continues through page 312, Industry Control and Manipulation of Nicotine, and then concludes with a breach of warranty claim for defectively designed products to Massachusetts citizens at page 336, exactly the same claim in this case. And all of those factual allegations and the breach of warranty claims are expressly incorporated into the 93A Section 4 claim at 340.
Okay, thank you very much, Attorney Trotch.
Thank you, Your Honor.
Attorney Humphreys.
Thank you and good morning. My name is Celine Humphreys, and I represent the plaintiff appellee, the estate of Mr. Laramie.
Could I ask you to start with the evidence issue as it relates to the FTC reports for a moment?
Yes, sir.
There's a lot of issues that flow from that, but just as sort of an initial point, how does the ancient documents exception eviscerate the rest of the law of evidence, such that just because something's in an ancient document, abracadabra, the rest of the law of evidence no longer applies as it relates to second-level hearsay, third-level hearsay, lay opinion, or whatever it might be? Because I think the FTC is really the results of a number of surveys, along with other information, and I don't know where your second-level exception is for that.
If I can make one point before I address your question directly. The initial point is we don't have to look at that because Philip Morris has waived the evidentiary issue at all because they did not appeal an alternative
Oh,
basis.
is this the public records issue?
Yes.
Well, if you grind down into the transcript, it doesn't look like Judge Davis made his ruling on the public records issue, but we'll read it line by line. But it doesn't look like he raised the public records exception, no doubt. But I don't think if you grind down into the transcript, that was his ultimate ruling. How is it that the ancient documents exception means that we should just throw out the rest of the law of evidence?
So frankly, what you're asking me is a question that has been debated a bit lately as far as the application of the ancient document exception, and particularly in modern day times. But of course, the long-standing tradition behind the ancient document exception is the fact that it was created so long ago that there's no concern that parties have somehow created it for
The party who created it.
Right.
So if you go all the way back to the Dallas County case, and where this all started as an ancient document, there's certain assurance that the first level of hearsay of when the church burned down in the small town has a level of reliability. That says nothing about second-level hearsay, third-level hearsay. The whole reason for the exception that mitigates the infirmities of hearsay as it relates to ancient documents doesn't exist to other levels of hearsay. I just don't understand how assuming relevance, and you've got a very strong argument on relevance grounds, and maybe there's first-level hearsay in the FTC report, I don't know. I don't understand how the other layers would fall within the exception.
So I guess I'm going to offer a few different answers, and I know you're particularly going to a scholarly point, but I'm initially going to remind the court of the cases we cited where this court and this jurisdiction recognizes totem hearsay or double hearsay or whatever the phrase in the context of hospital records.
Because the second level falls within an exception, like statement for medical diagnosis and treatment, and it's appropriately in the record. The second level hospital records exception doesn't mean, oh, it's in a hospital record, gosh, let's admit everything. The second level has to have its own exception.
Well, in that situation, well, I understand this. Actually, I disagree with you on that. I understand normally you have to have an exception for the initial document or the initial
That's the hospital
offer and
records
second.
exception.
But in the context of hospital records, my reading of the cases that we cited to you does not go to that examination at the second level. Also, what we provided you were numerous courts from numerous decisions from federal courts recognizing that the reasoning behind the ancient documents exception does apply to any hearsay within. I know you're pulling the thread of, should we abandon that? Should we change the law? Do we disagree with other jurisdictions?
Well, you've got the Ninth Circuit on your side, but not a heck of a lot else on your side on this argument. But we've never said something's in a hospital record, so even if it's a third party with no connection to the hospital, if there's no exception for that third party statement, that it nonetheless comes in because it's in a hospital record.
This is interesting. So hearing you say that, one of the things that I did was cite to you many other cases where the FTC reports have been repeatedly introduced into evidence in the cigarette litigation. And based on your analysis of what you just said about hospital records, that kind of thinking applies to the FTC reports.
Under the federal rules of evidence, there's a expansive federal exception as it relates to these type of public records that doesn't exist in Massachusetts.
Well, that's another point, and honestly, I wasn't trying to make that one. When I cited you cigarette cases where the FTC reports are admitted, they're not just federal cases, they're from other state jurisdictions. And the reason why me, a non-Massachusetts attorney, is here before you is I've been doing this cigarette litigation for more than 10 years, and I can tell you as an officer of the court that the FTC reports are routinely admitted. I know that's not persuasive authority, but that is me letting you know that jurisdictions not under just the federal umbrella of their rules and how they're broadly construed, these are routinely admitted. And you just helped me understand a way of explaining that. When you actually look at the record, and if you read broader, read some of the testimony of Dr. Cummings, who's an expert. Dr. Cummings is a man who has spent most of his career going through the thousands and thousands, even millions of documents, formerly internal secret documents of the cigarette companies, understanding them. He's an epidemiologist and whatever. And part of what he explains is also this process of the FTC and what the federal government did when it started playing catch up to understand the fraud here, understand the conspiracy. Remember, the federal government was late to the game.
We don't have a fraud or a conspiracy claim here, right? We have two claims.
Right.
Negligent distribution and the breach of warranty. So how does the FTC, and I don't mean to cut Justice Lowey off on the legal issue, but how is the FTC documents used to prove those two claims? Because both briefs don't spend a lot of time on what the actual claims are and applying the evidentiary issues to the claims were presented. So explain how the FTC document is used. And you may want to make a harmless error issue if there's an ancient document issue here.
Thank you. So harmless error. But also, if I can just say one more thing, if you look at the creation of the FTC reports, what the federal government was doing was using that kind of collaborative. It is a full-on task force. I'm not saying the governmental reports exception. I'm making the argument of the kind of process that goes into making those reports. I would posit to you is similar to what you're relying upon in the hospital.
How is
context.
it
But Justice
relevant to breach of
Kafka's point-
warranty?
Go ahead, Justice Wendland, I'm sorry.
How is it relevant to breach of warranty?
Right.
Okay, so it's relevant to the claim of breach of warranty, it's relevant to the defense put on by Philip Morris, and it's relative to the punitive damage request.
Yeah, my question was how?
How? So going through each one, the breach of warranty is premised on the consumer expectations and what the consumer knew. And so when you look at this, and one of the things that I did is I cited one of this court's cases that explains, I think it's Alio, that just because a cause of action is not pled, when different cause of actions can be premised on the same core facts, the fact that one of those actions is not pled does not make facts go away. Here, the facts are, not only was the product grossly defectively designed, the public and the understanding and their expectations of that, the fraud impacted that. So, and that's part of what's revealed in the documents and in the FTC reports. So for the public,
But I think both Justice Wendland and I would like sort of precision. So we got a breach of warranty design defect claim. We have
negligent
the
distribution.
FTC reports. We also are not a restatement second court. It looks like under Evans, we're a restatement third court. So given that the law should be restatement third, how is the FTC documents related to the breach of warranty claim? At least that's the question I have. I have trouble from the briefs because you're briefing fraud, conspiracy, and other things, but those aren't the claims.
Well, at a minimum, what I could answer you is the way that this case was tried and under the jury instructions given here defining the breach of warranty claim, none of which have been challenged on appeal, do make this evidence relevant because it goes to the person's knowledge of the defect. But acknowledging your point, then I will switch to two other points.
Well, but I'd like to understand it. So the FTC reports go in. Justice Lowy has raised issues about whether they go in under this ancient document. There are thousands of pages go in. The claim is that the cigarette could have been designed more safely, right?
More safely, yes.
So what do those documents do? Do they relate to that point? Are they all irrelevant and therefore harmless? I just can't follow it from the briefing.
So when I was talking about the warranty claim, I was focusing on consumer expectations. But yes, the documents do also go to the fact that how the product was designed and that it was intentionally designed to be addictive.
Okay, but again, so consumer expectations under the restatement third is one of many factors. It's not a predominant factor, right?
Yes, sir.
That's what Evans says very clearly.
Yes, sir.
So the FTC documents are only relevant to consumer expectations?
So I think part of what we're doing is conflating perhaps two of the arguments made by the defendants.
Okay.
When we're talking about this, when you're saying how is this relevant to the warranty claim, what the defendants really argued, that was under their separate attack that says we should not have been permitted to say anything about the fraud. So it was that type of evidence, the conspiracy, the concealment, the misrepresentation. So that's where I was going, and I know you're focusing in on the FTC reports.
Well, but again, he has a point that you don't have a fraud claim, you don't have a conspiracy claim,
Right.
so we shouldn't have thousands of pages of documents on something that you didn't plead.
Okay. So when you say thousands of pages, it's not...
I may be wrong. Is that inaccurate?
It's not thousands of pages. Let me, and I see where you're struggling, and if we weren't clear enough in the brief and responding, I'll be a little clearer. So where any of this evidence comes from that deals with the fraudulent conduct and the misrepresentations, the concealment, and the design of the cigarettes, intentional design of the cigarettes to be addictive, to cause addictive smoking so that people ingest enough carcinogens to get sick. Those came in from three places. Some of that came in from the few FTC documents that were shown to the jury, and that would be why it is a harmless error analysis at the end of the day on that. The rest of that came in through plaintiff's expert, Dr. Cummings. And Dr. Cummings testified at length, it's a good bit of the testimony, it's a lot of the plaintiff's case, at length describing various things, including the design of the cigarette, the concealment of the intentional design, and all of those facts. And in support of that, he would refer to documents, some of which were the FTC report excerpts, and the rest are mostly formerly secret internal company documents. So that's where this is all coming from. So I think what you're really asking about, if I understand correctly, is how can we be introducing any of that you're focusing just on the breach of warranty account. And my response is, obviously, evidence regarding the defectiveness of the design of the cigarette, and some of that is in the FTC reports. You all are fine with that. Your concern is anything that has to do with the concealment. And so that is relevant because one of the factors for the jury to consider is the consumer expectations. And at a minimum, that was how this case was tried. So under our affirmative burden, and that's...
But consumer, I think your opposing counsel makes the point that consumer expectations can't be based on secret documents they don't know about, right?
I can respond to that.
Go ahead.
And so the reason why those secret documents, there's no necessity that Fred Laramie heard about secret documents or he read them or that they were on the news with Walter Cronkite. What the secret documents do, and this is another fact we must not have conveyed well enough, they're remarkable. The defendants themselves, like somebody writes in a journal every night, cataloged every step of what they were doing. Every step, including...
The question, counsel, is how could that internal document
Right.
possibly set the expectations of somebody who has never seen them?
Okay, I was trying to answer that, and apparently I'm not. So the reason is, what they did is they document their attempt to mislead the public. They document how much money they spend, billions on misleading the public. They themselves describe their purposeful intent to impact the expectations and the knowledge of the public. So it's...
Which you're saying makes the product dangerous.
Makes the product, no, that's two factors. They document how they intentionally make the product effective, and they also equally document their collective conspiracy starting in 1953 to hide that from the public, to attack the Surgeon General. So it's akin to, in a criminal case, an admission. They themselves, it's not the same, so please, I'm not trying to pull that thread, but they themselves make the case that they are purposely and intentionally misleading the public. And I have to close the loop on this because I know you're focusing on the warranty count, but please know all of this is equally made relevant for two other purposes. One is the defendant's own defense, where they repeatedly argue that it was Fred Laramie's choice. So if you're disagreeing with me on the warranty count or not understanding, saying a person didn't see it, it's still equally relevant to a person's own choice, and it's just as relevant, separate, independently.
That gets to the jury, the mistaken jury instruction, what the appellants are saying is the mistaken jury instruction. Because, what you just said is that, that this evidence rebuts the defense that, well, it was Mr. Laramie's choice. And throughout the trial, the judge is saying, as a matter of law, the warning labels on the cigarette packages are sufficient to inform the public of the hazards. I'm not sure that actually is correct in this case. I think that's where everything sort of goes awry when the judge, I think he probably figures it out himself. And in his final instruction, he adds an instruction that is concerning. The law doesn't allow tobacco companies to mislead consumers or make misrepresentations. That can't have anything to do with the causes of action. It seems like it's almost trying to do a makeup call for an instruction that really shouldn't have been given throughout the trial, considering rebutting the defense here.
I disagree respectfully. So part of what I do agree with is how we got there, and I'll address that in a moment. But I do want to make clear that that final sentence is absolutely an accurate statement of the law. The statement under the law, under the United States Supreme Court precedent...
Let's assume it is.
Okay.
It still has to have something to do with the cause of action before the court. You can have all sorts of statements of jury instructions that are accurate, but if they're not applicable, they send the jury down the wrong road.
So that's interesting. I did not think of approaching it that way. I'll say a couple things if I can respond. The initial problem created, and this would come under the penumbra of invited error. The initial problem created was the bulk of this jury instruction was requested by Philip Morris inappropriately, and the court granted it.
Exactly, that's what I just said.
right.
That's what I just said. The problem is Judge Davis figures that out at some point in the final instructions and is trying to walk back that instruction that just eats away at rebutting the defense.
I would agree with that, but not to the extent that it then means that the whole instruction is error. If there is a problem on that basis alone, it's under invited error. But I do also want to say we would not have requested this had Philip Morris done that. That does not mean that now we have a jury that is affirmatively misled in any sort of way. What we instead have is Philip Morris repeatedly and incorrectly arguing to the jury, it's not a correct legal conclusion, that the fact that the warning labels are on the cigarettes, they are facially sufficient, that the jury must accept them as adequate as a matter of law to warn Mr. Laramie. That is not correct under the law. Philip Morris then used that instruction to buttress its defense of choice, saying, all right, even if the plaintiff establishes their cause of action, we're still not responsible. So the cigarettes may have caused his illness and death, but that was his own choice to use that deadly product. It wasn't because of us. And so that was an improper instruction to tell the jury that.
This is not right. This is not a warning neutralization Cipollone situation. That's not what this case is about.
Correct.
But your problem is this case is also not about what that instruction says.
Okay, I can respond to that. Our case is not affirmatively about that, but it became relevant because of Philip Morris's defense. When they argued choice, they made it relevant. So if you're asking me, would I have requested the judge to give this instruction just so I can be proving my cause of action warranty? No, sir, I'm not suggesting that. Our argument is that when the defense then responded and said, because one of the interesting things about cigarette cases, in most cases when you have product liability, the question is, was the Ford defective and did it cause injury? Did the light explode and cause injury, because it was defective? Here, there's no question that the cigarettes caused injury. It's a different kind of case. Instead, the causation question is, did the individual choose to use the cigarette often enough, long enough to become addicted? Or not even become, just chose to smoke for 40 years? Or is it something about how the cigarette was designed that made the person addicted? So the defense argues to respond to that, hey, it wasn't, I know our cigarettes are made to be addictive, I know they're powerfully addictive, but this person was not addicted, this person chose to smoke. That's what the choose to smoke defense is. And when the defendants made that argument, and they say he chose the smoke despite reading these warning labels, and did it anyways, willy-nilly, we were allowed to respond, yes, but that doesn't mean that that was okay. And that also goes to punitive damages. I hope I've answered your question.
Okay.
I am significantly over time. I don't know if the court wants to hear from me at all on the punitive damages issue, or if I've answered your other questions.
Everybody else set? Okay, thank you very much.
It was a privilege to appear before you. Thank you.
Thank you, Your Honor.